Alright people, so welcome to Jumbo IS and welcome to our current affairs lecture series. Now today, the subject which we'll cover in this particular lecture series is Indian polity. So all the important current affairs from the past 1 week related to the subject of Indian polity shall be covered in today's lecture within 30 minutes. Okay. Now needless to say this, but I'll still say it, that make this lecture series a part of your daily routine. It should be your daily habit. If you develop this habit, you'll just have to spend 45 minutes of your day, 30 minutes of watching the lecture and 15 minutes of revising it from the notes. But these 45 minutes, well, till your exams, if they become a part of your daily routine, till your exams, you would be miles ahead of your competitors, miles ahead. Okay, so make it a part of your daily routine. All right, without further introduction, let's straight away dive into the lecture. So let's begin. So current affairs Indian polity, July part 2, and here are the topics that we shall cover. So topic number 1 is related to a Supreme Court judgment, procedural fairness in citizenship adjudication. Basically, Guwahati High Court gave a series of judgments. Guwahati High Court gave a series of judgments with respect to citizenship. Okay, now Supreme Court basically cancelled those judgments. So we'll talk about the entire issue. All right. Okay. Then topic number 2 is landmark judgment on judicial salaries. Basically, the Supreme Court has said that you cannot delay judicial salaries, okay, salaries of judges. And various other important points were covered. And various constitutional articles were covered under this. So it's an important judgment from the standpoint of Constitution of India. So we'll cover this, very important. And the last topic is also related to judiciary, managing judicial backlogs, pendency in the courts of India. So this is topic number 3. So as you can see, all 3 topics are related to judiciary. This was a judiciary specific week when it comes to Indian polity current affairs. Nonetheless, judiciary is also part of our syllabus. So let's discuss all 3 topics. Let's focus our attention on these 3 topics. Let's discuss them one by one. Starting with topic number 1, and that is procedural fairness in citizenship adjudication. Now listen to me very carefully. You know, when your citizenship is in question, when the government finds out that this person is residing in India illegally and he or she is not a citizen of India, the matter goes to foreigners tribunal. These are special quasi-judicial bodies that adjudicate citizenship related cases. Now, these foreigners tribunal basically designated certain illegal immigrants as illegals, foreigners, and gave the order of deporting them. Now, these people basically who were branded as illegals or branded as foreigners, they have said that foreigners tribunal did not follow the due process. They just listened to the government. Okay, due process is a judge listens to both sides and then comes to a judgment. But these people have alleged that, well, the judge in the foreigners tribunal did not listen to their side of the story. They just listened to the government side of the story and passed a judgment. So they did not follow the due process. Hence, well, this entire case should be heard afresh. So they filed an appeal against the judgment of Foreigners Tribunal in Guwahati High Court. Guess with whom Guwahati High Court sided with? Okay, Guwahati High Court actually sided with Foreigners Tribunal, and again reiterated the stand that these people are foreigners. Now they appealed against the Guwahati High Court's judgment in the Honorable Supreme Court, and Honorable Supreme Court said that no, this is wrong. You should follow due process. Even if there is very strong chance that these people are foreigners, even if the evidence against them is paramount, is undeniable, then too you should hear their side of the story because you need to follow the proper procedure. Hence, hear these cases afresh again. Clear? Now, while giving this judgment, Supreme Court also cited various constitutional articles. Now, because Supreme Court cited constitutional articles, it becomes important for us UPSC aspirants. Okay, so let's talk about this issue in its entirety. Let's begin. So procedural fairness in citizenship adjudication. Okay, so in a landmark ruling, the Supreme Court of India set aside a cluster of 27 Guwahati High Court judgments. There were 27 Guwahati High Court judgments which agreed with foreigners tribunals set up in Assam. As you all know, Assam has this huge problem of illegal immigration from Bangladesh. Okay. Supreme Court remanded these cases back to foreigners tribunal. So what has the Supreme Court ordered? Supreme Court is not saying that these people are citizens. Okay, Supreme Court is not overturning the judgment. Make this distinction. Supreme Court is not overturning the judgment. Supreme Court is saying that, well, because foreigners tribunal did not hear the case with proper procedure, due process was not followed. Hence, you need to hear these cases afresh. Okay, and follow due process this time. This was ordered by Supreme Court. Okay. Now, what legal principles, what constitutional principles were used by Supreme Court while giving this judgment? Okay. So, number one principle that the Supreme Court used was applicability of fundamental rights to non-citizens. You see, there are only a few articles. You should know this. Article 15, 16, 19. Just a second. 19, 29 and 30. Only these fundamental rights are available to citizens. Rest, all the other fundamental rights are available to both citizens as well as foreigners. Now, Supreme Court used Article 14, which is right to equality, and right to life, Article 21. Because these two articles are available to non-citizens as well, utilizing them, Supreme Court said that these people whose citizenship hangs in a balance, well, they are entitled to free and fair trial. If you are not giving them fair trial, you are discriminating against them, which is against right to equality. And right to reasonable fair trial is part of your right to life under Article 21. So Supreme Court used this. Then Section 9 of Foreigners Act. Now this is a very important legal principle. Section 9 of Foreigners Act says that if government finds out that you're not a citizen and government alleges that you're not a citizen, the onus of proof is on you. You have to prove your citizenship. It is not up to the government to prove that you're not a citizen. You have to prove whether you're a citizen or not. Okay? So the government cited this. Government said that since the onus of proof is on the person, well, the government said these people are non-citizens. Government showed some proof and the Foreigners Tribunal gave the judgment. But Supreme Court has said, yes, Section 9 says the onus of proof is on the person. Yet, that doesn't mean that that person does not even have the right to be heard. Okay, right to give their version of story. Okay, this is a very important legal principle, and its Latin version says audi alterum partem, which means hear the other side. Even if the onus of proof is on the person, okay, well, that person still has the right to narrate their story. So using that, we are cancelling these judgments and we are ordering Foreigners Tribunal to basically hear these cases afresh. You understand this? Okay. Now, what other observations were made by the Supreme Court? Supreme Court said that, well, this was an abuse of ex parte orders. Now, what are ex parte orders? You need to know this. Tribunals frequently declared individuals as foreigners via ex parte, one-sided proceedings. And one-sided means just listening to the government. An ex parte order is those orders which are given by just hearing one side of the story without hearing the other side. Proceedings due to non-appearance. The court ruled that minor typographical discrepancies, spelling errors and all, should not be used as mechanically to strip someone of citizenship without proper notice or verification. And the evidence presented by the government authorities was that, look, his Aadhaar card's name and voter card's name is different. And what was the difference? Normal spelling error. So based on this, you can't refuse to hear the other side. Okay, so this was there. High courts and tribunals cannot act as mere rubber stamps. The Apex Court demanded a reasoned, independent and application of mind to unique facts. Right to have rights, basically. Okay, now, underlying institutional challenges. You see, this is all right. Okay, foreigner tribunals have to hear these cases again. But India's foreigners tribunals also face severe challenges, and these challenges were pointed out by the Supreme Court. What are these challenges? First of all, lack of judicial standardization. You see, these foreigner tribunals are tribunals. Okay, the people who give judgments in these foreigner tribunals are not called judges, they are called members. Though most of them are ex-judges, but they are called members. Okay, now these members have certain problems. Okay, foreigner tribunals are quasi-judicial bodies. The members often lack the rigorous training of regular judiciary, leading to inconsistent application of evidence laws. Because sometimes these members are non-judicial members. They are not well versed with the procedures followed in judiciary, that it is important to follow principles of natural justice, due process. Hence, they give faulty judgments. Documentation vulnerabilities. Marginalized and rural populations lack flawless legacy data, birth certificates, land records, minor spelling variations, and sometimes these spelling variations are caused because of translation of their name or documents from local language to English. So these can also cause a harm to your claim to citizenship. So this is a problem. Plus there is high pendency in foreigners tribunals. Because there is high pendency of cases, therefore these members are pressurized to adjudicate cases very quickly. And sometimes in haste, they give faulty judgments. Okay, so these are the challenges that are already there in foreigners tribunals. Okay, that is why their judgments are contested from every now and then. Now, what is the way forward? Capacity building, train judges, train members, okay, standard operating procedures, give certain rules that every member of foreigner tribunal should follow. Then legal aid integration. Well, people who cannot afford lawyers, well, they should be given free legal aid, free lawyer services to these tribunals also. Legal aid is provided in High Court, District Court, Supreme Court, not in foreigners tribunals. This should be integrated with foreigners tribunals as well, so that people have good advice while fighting their cases. Okay, so this is the thing, this is the way forward. That's about it. I hope you understood the entire issue, right? And now let's quickly shift our focus to next news item, and that is landmark judgment on judicial salaries. Now hear me out very carefully. You see, the thing is that, well, judges are entitled to a particular salary. Okay, all judges. Now that salary cannot be varied to their disadvantage. This is written in the Constitution. The Constitution says that judges' salary would be decided by the legislature, but it cannot be varied to their disadvantage. What does that mean? It means that once you have appointed a judge on a particular salary, then you cannot change that judge's salary. Okay, and you can change, but you can only increase, not decrease. So once a judge is appointed on a particular salary, his salary cannot be decreased. Okay, if you want to decrease the salary of judges, then pass a law and future judges' salary would be decreased. But if you have appointed this judge on 2 lakh rupees per month, he will receive 2 lakh rupees per month till his entire tenure. You can only increase it, not decrease it. Okay, so their salary cannot be varied to their disadvantage, except in financial emergency, but that is understandable, right? Now, the reason why this provision is justified, that their salaries cannot be varied to their disadvantage, is to ensure judicial independence. Because if you can blackmail judges that please give this judgment, if the government can blackmail judges that give this judgment or otherwise I'll reduce your salary, okay, then judges won't give a judgment free of fear. To ensure judicial independence, well, you have kept their salaries intact, right? But sometimes the executive, they cannot reduce their salary, but they delay their salary. And this doesn't happen with High Court or Supreme Court judges, but it happens with District Court judges. Sometimes their salaries are delayed. And the reason given behind that delay is that currently we do not have funds, there are fiscal problems, there are financial problems, treasury problems, so we'll give your salary after 2-3 months. Now recently, Supreme Court has opined that delaying a judge's salary also amounts to, well, harming judicial independence. Delaying a judge's salary also amounts to not giving them salary. And this is wrong, because judicial independence is part of basic structure of the Constitution. You cannot alter it. So you have to give judges salary on time. Make sense? This was the entire case. Now let's discuss it in more detail. Okay, so let's begin. So landmark judgment on salaries. So the case's name is All India Judges Association versus Union of India. Basically, Second National Judicial Pay Commission was established. Okay, this Judicial Pay Commission decides salaries. Like we have pay commission for government employees, there is pay commission for judges. They decide salaries, pensions for judges. Okay, and this is for all judges, Supreme, High, District, all judges. Okay. Now the recommendations given by this Judicial Pay Commission are, well, those recommendations are not being implemented for district judges by state governments. So this Pay Commission said that increase judges' salary, but the state governments are not able to give those salaries. They are citing that they have fiscal problems, they have budget constraints. Okay. Now this case went to the Supreme Court and Supreme Court said, no, you can't do it. You have to implement Second National Judicial Pay Commission's recommendations. You have to implement them. Clear? Now, what has the Supreme Court order highlighted? So core constitutional principles asserted by Supreme Court. First of all, judicial independence is part of basic structure, and by delaying their salary, you are harming their judicial independence. In fact, you are harming basic structure. Okay. Then, Supreme Court also highlighted doctrine of separation of powers. Now, what does this doctrine say? Okay, basically the executive has said that look, a judge's salary should be at par with a bureaucrat's salary. So a very high level IS officer, their salary and a judge's salary should be at par. Both of them are officers of the government. Okay. Now the Supreme Court basically said no. The government was saying that 7th Pay Commission, 8th Pay Commission also gives recommendations on salaries of bureaucrats. So based on that recommendation, 7th or 8th Pay Commissions, judges' salary should be also given. Supreme Court said no. For judges, a separate pay commission, which is Judicial Pay Commission, only that will be established because there is separation of powers. Our constitutional principle is doctrine of separation of powers, that executive, legislature and judiciary are separate. They should be treated separate. So bureaucrat, which is part of the executive, and judges are two different entities, so we will have different salary systems. And principle of unified judiciary. Basically, Supreme Court said that Supreme Court judge, High Court judge and District Court judge, they are all part of one unified judiciary. So if you are increasing the salary of Supreme Court judges, High Court judges, but not increasing the salary of District Court judges in proportionate terms, then you are violating this unified judiciary principle. Okay? If you are increasing the salary of Supreme Court judges by 2x, well, you have to increase District Court judges' salary also by 2x. That was the principle. Okay? Increase the salaries of all or none. This was the idea. Clear? Now, major institutional friction points, which means what is the conflict between judiciary and executive. Okay? Well, the executive says that such high salaries puts a financial burden on them. You see, the executive is saying that if you tell us to decide the salaries, we would decide salaries based on our budget. But we are not allowed to discuss judges' salaries. You create a separate judicial commission, Judicial Pay Commission, which is empowered to decide judges' salary. And these Judicial Pay Commissions are made up of judges only. And they decide very high salaries. And these high salaries, well, do not work out for us. It puts a financial burden on us. Then executive parity, they are also saying that if a high level government official is entitled to this salary, well, a judge should also be entitled to a similar salary. There should be parity, which the Supreme Court said no. Okay? Separation of judiciary and executive plus financial burden. Supreme Court said financial burden is not a ground to deny judges their salary because judicial independence is part of basic structure. Clear? Now, what is the way forward? Well, strengthening subordinate judiciary, district court and judges, timely fiscal devolution. Well, you should create a separate fund for judges' salary so that even if there are budget constraints, you still have the money. And reducing corruption vulnerabilities. A well-compensated lower judiciary structurally lowers vulnerability to external pressures and institutional corruption. Well, this is the way forward to improve lower judiciary basically. Okay, but the main matter was this one. Clear? All right. Now let's move on to last news item of the day, and that is managing judicial backlogs. So you see, this fact, well, we are all aware of this, that our judiciary suffers from pendency of cases, judicial delays, huge case backlog. That means that our judiciary is not that efficient. And that is why there is this huge pile of pending cases. And that leads to delayed justice, delays. And there is this very famous saying, justice delayed is justice denied, right? So we have to solve this problem of judicial backlog. Now, Supreme Court has given certain recommendations on this, plus Supreme Court has also taken some actions to reduce judicial backlog in all levels of judiciary. So what are those actions and what are those recommendations? Let's take a look at that, okay? Use this line, justice delayed is justice denied, okay? Managing judicial backlogs. So data from National Judicial Data Grid. So this is an online portal which gives you the data on all cases that are filed all over India. Highlights that judicial pendency across all tiers, Supreme, High, District, in Indian legal system has crossed a critical threshold of 56 million cases. That means 5.6 crore cases in India are pending. This is huge across all levels. More than 85% of this backlog is concentrated in district and subordinate courts. High courts collectively account for 6 million cases, while the Supreme Court has 94,000 pending cases. Okay, so 85% of pending cases comes from district courts and subordinate courts. That means they are not working efficiently. Now, To measure pendency, well, we have two units, two metrics, okay, clearance versus congestion rates. So to measure how many cases are pending, we use two metrics, clearance rate, congestion rate. What is clearance rate? It is calculated by dividing total cases disposed of by total cases instituted in a given year. So if today in Supreme Court, if in 1 year 100 new cases came to Supreme Court and Supreme Court disposed of 200 cases, okay, so it is dividing total cases disposed, sorry, let me explain it in a more neat way. So basically what happens is that if Supreme Court has disposed of 200 cases in 1 year and in that same year it received 100 new cases, that means it is disposing of more cases than it is receiving, so the number is 0.5. But if it disposed of 200 cases and received 400 new cases, the number would have been 2. When this number is clearance rate. When this number is greater than 1, that means the court is receiving more cases than it is disposing of. It is bad. Clearance rate greater than 1 is bad. Then there is congestion rate. It is very fascinating. Measures how long a court would take to completely clear its backlog if all fresh cases are frozen. So in Supreme Court, if no new case comes, then how much time will it take for Supreme Court to clear all its backlog? 1.4 years. This is known as congestion rate. Now currently both clearance rate and congestion rate is really high at all levels, but extremely high at lower levels of judiciary. Okay. Now, what are the reasons behind this? Number one, unfavorable judge to population ratio. Currently we have 21 judges per million people. But Justice Malimat Committee said that we need 50 judges per million people. So we have a shortage of judges. To make our judiciary really efficient, we need 50 judges per million people, but we have less than half of that. So we do not have required infrastructure, okay, judicial infrastructure. Then there is inadequate infrastructure, digital divided subordinate courts and digitally divided subordinate courts. We do not have good infrastructure at lower judiciary. We do not have enough chambers for judges, enough courtrooms for judges. Then the government has launched, or the courts have launched, e-courts project, or it has launched various tech initiatives to improve the efficiency of courts. But many of these courts are in remote locations where there is no internet access. Okay. So because of that, there is this shortage. Plus, you know why we have so many cases? Because government files so many cases. Government is the biggest litigant. Around 45 to 50% cases in our courts are filed by government. If someone is not paying income tax, government files a case. Okay. So government is the number one filer of case, if that is a phrase, but though it is grammatically incorrect what I just said. Government is the number one litigant. Government needs to reduce its litigant nature a little bit. This is the reason. So these are the three big reasons: shortage of judges, inadequate infrastructure, especially digital infrastructure, and government's hyper litigant nature. Okay. Now, what is the way forward? Well, differentiated case management and specialized benches. Well, you should divide cases into three categories. Okay. Fast track cases, cases that need quick judgments. So put them in fast track category. Then normal cases. And the third is nuanced, complicated cases which require specialization. And arrange these cases, administer these cases, their hearings should be scheduled in a proper way. Okay, so divide the cases in these three categories and manage them accordingly. So differentiated case management, and create specialized benches. For example, if there is a complicated financial case, then create a bench of those judges which have some financial knowledge also, a degree in economics also, right? Do this. Then technological scalability, implement e-courts project in every part of the country. Then this is the biggest thing that we can do: alternate dispute resolution. Alternate dispute resolution means that you settle the matter outside the court. So we have this system of lok adalats, where two parties come and they resolve their dispute through mediation. Okay. So instead of going to the High Court, resolve your dispute like normal marriage, divorce disputes in Lok Adalats. Because if you do that, well, you would put less burden on the judiciary. So you need to make alternative dispute resolution mechanisms mandatory for certain category of commercial, domestic cases, marriage cases. Make it mandatory that you cannot go to High Court unless you go to a Lok Adalat first. So certain categories of commercial cases, certain categories of marriage cases, certain category of divorce cases should first go to a Lok Adalat, should go to a Lok Adalat. You make it mandatory for them. Only then you will be able to reduce that burden. Clear? Make sense? So this is the way forward. And that would be all. With that, we conclude today's session. So thank you so much for watching, everyone. And I'm sure it has added value to your preparation. I'm sure about it. Just follow these two things. Be consistent and regular with this lecture series. And number two, please do not forget to revise this lecture from the notes provided by us. The notes are shared on our Telegram channel, and the link to our Telegram channel is provided in the comment section below. So please do not forget to do that. And I shall take your leave with the promise of seeing you again with another set of news items. Thank you, everyone.